Namaskar. So we'll be discussing fundamental rights. Why are they called fundamental? The amendability of fundamental rights and the doctrine of basic structure. So what are fundamental rights and why are they called fundamental? Fundamental rights as such are based on the Bill of Rights. Fundamental rights have been derived from the US Constitution. Part 3 of the Indian Constitution captures the fundamental rights. Fundamental rights have been enshrined under Part 3 of the Indian Constitution. Fundamental rights are such eminent that they have been called as the conscience of the Indian Constitution. They are called as the heart and soul of the Indian Constitution. Not only this, but also the cornerstone of Indian democracy. Fundamental rights act as a negative obligation to the state. The state is bound to protect the fundamental rights. State is under the bounden duty to protect the fundamental rights, and therefore it very well captures the doctrine of limited government. Why so? Because it prevents the state from becoming authoritarian. So doctrine of limited government is inherent in the fundamental rights, that is part 3 of the Constitution. Now they are called fundamental for the very reason, see, every human being is unique. Every human being is born with some unique talent. And to realize the physical and intellectual potential to the optimum of that particular talent, to exhibit that uniqueness, a person requires certain basic rights. Those basic rights are nothing but the fundamental rights. They are the rights which are required to realize the optimum physical and intellectual stature of the talent that particular individual possesses. Fundamental rights seek to establish political democracy within India, whereas directive principles of state policy seek to establish social and economic democracy, which we'll eventually discuss. Now, there are certain rights which are available only and only to Indian citizens, but all other rights are also available to foreign citizens, which we'll discuss eventually. So as far as the amendability of fundamental rights is concerned, what is most relevant and important is Article 13 of the Constitution of India. Why so? Because Article 13 captures the doctrine of judicial review explicitly in case of infringement of any or more of the fundamental rights. Now, if we discuss the amendability of fundamental rights, what cannot be left behind is the doctrine of basic structure and the history behind the same. So we'll be discussing both in tandem. Now, Article 13 Clause 2 explicitly provides and it restricts the state that the state shall not make any law which takes away or abridges any or more of the fundamental rights, and such law shall be declared unconstitutional and void. Meaning thereby, any law that is enacted by the state which is in derogation with or is inconsistent with Part 3 of the Constitution of India shall be declared as unconstitutional and void. Now we'll go back in history, because to trace the roots of doctrine of basic structure, we have to go back to the embryonic origin of the same, which lies under the first Constitutional Amendment Act of 1951. Now what happened was, in the first Constitutional Amendment Act, there were primarily 3 changes made. The very first change was adding Article 31A, restricting the right to property, and also adding Schedule 9 to the Constitution of India. And the very significant change was introduction of Article 15 Clause 4, which provided special provisions for socially and educationally backward classes. Now this very amendment was put to test and was challenged in Shankari Prasad versus Union of India 1951. Now the Honorable Supreme Court of India in Shankari Prasad versus Union of India held that the Parliament was competent. The Parliament was competent to amend any and every part of the Constitution of India, including the fundamental rights. And the Supreme Court had gone on to hold that as far as the Constitution amending power of the Parliament is concerned, it is available to the Parliament under the constituent law making power, which is comparable to the power of Constituent Assembly. And as such, the constituent law making power of the Parliament does not come under the ambit of the term law as described under Article 13 of the Constitution. And the other power available to the Parliament was the legislative law making power, which comes under the ambit of the term law. And as far as the legislative law making power of the Parliament is concerned, the Parliament cannot make any such law which is inconsistent with Article 13 or Part 3 for that matter, and therefore hence that law would be declared to be unconstitutional and void. In these circumstances, it is inconsistent with Part 3 of the Constitution and not by virtue of a constituent law-making power, if any law is made, it would be declared as unconstitutional and void, meaning thereby that the Parliament was competent to amend any and every part of the Constitution under the constituent law-making power, making the Parliament completely omnipotent. Now, this very position of law was settled and was prevalent and was implemented till 1965, that is Sajjan Singh versus State of Rajasthan. Now, things took a contrary shape and everything was overturned in a landmark case again, that is Golaknath versus State of Punjab 1967. Now, what happened in Golaknath versus State of Punjab was that the Honorable Supreme Court overruled its own decision. Now, the Honorable Supreme Court had held that as Article 368 of the Indian Constitution only provides for the procedure to amend the Constitution and does not provide the power thereof. So, therefore, the Parliament was not competent enough to amend any or every part of the Constitution, including the fundamental rights. Therefore, the Parliament did not have any constituent law-making power, and any and every law which is made by the Parliament would come under the ambit of the term law as contained in Article 13 of the Constitution, meaning thereby that the Parliament became completely redundant and Parliament could not amend any part of the Constitution, including the Part 3, that is the fundamental right. Now, the Parliament was bound to respond as a consequence of the Golaknath judgment in 1967, and the Parliament reacted by enacting the 24th Constitutional Amendment Act of 1971, wherein significant changes were made in the Constitution. The very first change was changing the title of Article 368, which now reads, "Power to amend the Constitution and procedure therefore." Because the very reasoning which was given in Golaknath versus State of Punjab was that Article 368 provided only for the procedure to amend the Constitution and did not provide the power, as we have discussed. So the very first significant change as a consequence of the 24th Constitutional Amendment Act was that the title of Article 368 was changed, and now it reads as "Power to amend the Constitution and procedure therefore." Now, the second significant change was introduction of Clause 3 within Article 368, which now reads that nothing in Article 13 will include a Constitutional Amendment Act as under Article 368. And the last significant change as a consequence of the 24th Constitutional Amendment Act was introduction of Article 13 Clause 4 within the Constitution of India, which reads that nothing in this article shall include a Constitutional Amendment Act as under Article 368. Now, this very amendment, that is the 24th Constitutional Amendment Act of 1971, was put to test. It was challenged before the Honorable Supreme Court of India in Kesavananda Bharati versus State of Kerala. And in that very judgment, that is the landmark judgment passed by the Honorable Supreme Court of India, which has changed the constitutional history of India altogether, it was held that the Parliament enjoyed both the constituent lawmaking power as well as the legislative lawmaking power. Now, as far as the constituent lawmaking power is concerned, the Parliament was competent to amend any and every part of the Constitution, including Part 3. But as far as the legislative lawmaking power of the Parliament is concerned, it comes under the ambit of the term law as provided under Article 13. But there was a rider introduced in the Kesavananda Bharati judgment, that is, that while exercising the constituent lawmaking power, the Parliament would keep in mind the very fact that any and every amendment, including amendment in the fundamental rights, shall not violate the basic structure of the Constitution. Here was the basic structure born, that is in the Kesavananda Bharati judgment. And such is the doctrine of basic structure that it has evolved since 1973 and is ever evolving. There are many ideas, there are many parts of the Constitution of India which are part of the basic structure of the Constitution and are still evolving to become the parts. So therefore, doctrine of basic structure is a judicial innovation in the matter of Kesavananda Bharati versus State of Kerala in 1973. And the basic structure of the Constitution has been based on the eternal structure of the Weimar Constitution, that is the German Constitution. So there are certain concepts and ideas which form the part of the basic structure of the Constitution as such, and they have evolved in respective judgments of the Honorable Supreme Court of India. Many ideas have respectively been dealt with and have been held to be the part of the basic structure of the Constitution, which would be given as a list at the end of this very lecture. But some, for example, I'll be dealing now, are the sovereignty of India, the unity and integrity of India, free and fair elections, not all fundamental rights. Remember, not all fundamental rights, but only 4 fundamental rights form part of the basic structure. That is Article 14, 15, 19 and 21. They are only part of the basic structure of the constitution and not all other fundamental rights. Some other concepts are separation of powers, rule of law, judicial review, doctrine of welfare state. They all form part of the basic structure. The list would be given at the end of the lecture. Now, in the constitutional history, the story doesn't stop here. The parliament responded to the judgment passed in Kesavananda Bharati versus State of Kerala by enacting the 42nd Constitutional Amendment Act. The 42nd Constitutional Amendment Act was enacted in the year 1976. As a consequence of which, there were two changes made. Clause 4 and Clause 5 were added to Article 368 of the Constitution. Now, Clause 4 of Article 368 provided that any and every constitutional amendment cannot be challenged before the court of law. And Clause 5 provided that the Parliament had unlimited powers to amend the Constitution. Now, this very amendment was put to test and was challenged before the Honorable Supreme Court of India in Minerva Mills versus Union of India 1980 matter. Now, the Honorable Supreme Court of India in Minerva Mills versus Union of India 1980 held the Clause 4 and Clause 5 as introduced by the 42nd Constitutional Amendment Act to be completely unconstitutional and void, and while exercising the power of judicial review, it reinforced that any and every amendment which is made by the Parliament of India shall be in coherence with the basic structure of the Constitution, and the power of judicial review also forms the part of the basic structure of the Constitution, reinforcing the eminence of judicial review, reinforcing the balance among the three organs of the state. Therefore, the position of law is that Parliament is competent to amend any and every part of the Constitution, including fundamental rights, but such an amendment shall not be inconsistent with, shall not be incongruent to the very basic structure of the Constitution.